Hi, Josh.
Hi, Amanda. What are we talking about today?
Today, we're going to talk about non-compete agreements. Really typical scenario that I see a lot, and I'm sure you do too, is a potential client comes in to see me and they've signed a non-compete with a previous employer. They're now working at a subsequent job, really happy, things are going great, and they receive a cease and desist letter from a law firm that's representing their prior employer. And they're quite reasonably freaking out a little bit, right? They don't typically receive this type of correspondence from a law firm and they don't know what to do. And they show up in my office and they say, help me. Let's chat with the employees in Connecticut and let them know, what do you do when this happens?
Yeah, I do a lot of this non-compete defense representing employees who are concerned about the enforcement of non-compete. So first step, take a breath. You're not the first person to get a letter like this. Nobody's going to jail about this. Nobody's going to die. This is going to be okay. This letter, frankly, might just be a scare tactic. And your former employer is not really interested in taking it any further. They just want to sort of put you on notice, right? So at that point, nothing's happened so far. But let's say you didn't just get a cease and desist letter, you got served with a lawsuit. Right now, you're a defendant in a lawsuit. And for a lot of people, that's their first ever lawsuit. They're really uncomfortable. So the good news to start off with is not every non-compete agreement is enforceable, right? This is a question of state law. So in Connecticut, non-competes are sometimes enforceable and sometimes not, and other states have other rules. So Massachusetts, for example, has a statute about non-competes. California basically doesn't enforce non-competes. But here in Connecticut, the rule is your non-compete is enforceable to the extent it's reasonable, which of course just sort of begs the question, what does that mean? Well, the courts use a 5-factor analysis to consider whether a non-compete is enforceable. And the 5 factors are the geographic scope of the non-compete, the temporal scope of the non-compete. So how many miles is it? How long does it last? The legitimate business interest of the employer, the employee's ability to earn a living, and the public interest, whatever exactly that means. So all of them are a little bit nebulous, but if the non-compete is unreasonable on any one of those 5 factors, then it is unenforceable as a matter of law. The problem here for employees, and frankly for employers too, is that there aren't any hard and fast rules. Nobody really knows exactly how many miles is reasonable or unreasonable. Nobody really knows exactly how many months or years is reasonable or unreasonable. It's sort of like that famous Supreme Court quote about pornography, you know it when you see it. And so if you do enough of this non-compete work, you sort of get a sense. But for the average person who's getting the average Connecticut worker who's getting a letter, a cease and desist letter, or a lawsuit, they're really not in a position to evaluate the merits of that. And unfortunately, that means they need to go talk to a lawyer, right? Like us. And I wish that wasn't the case. So one of the things we've done is we at Garrison Levin-Epstein have supported legislation that would provide some clearer guidance for both employers and employees on the issue of non-competes. A couple of bills were considered by the Connecticut General Assembly this session, but unfortunately they didn't make it ultimately through the committee process. So if a non-compete is something you're worried about in the short term, one thing you can do is just talk to a lawyer about your non-compete, figure out if it's actually going to be enforceable. But another thing you could do, frankly, something that might make a difference for a lot of people, is consider giving your legislator a call. Call your member, your representative or your state senator and say, hey, I've got a non-compete. I'm concerned about it. This is a priority for me as your constituent. And I really hope that you will take some action in future sessions to make sure that we have more predictability here. Non-competes are a tool that a lot of companies are using, not just against, or with respect to their senior executives, but Jimmy John's famously had a non-compete with respect to so-called sandwich artists. That's ridiculous, right? Nobody earning close to the minimum wage should be prohibited from taking any job they can get to improve their situation. And states like Massachusetts have really taken that lesson to heart. And I think Connecticut hopefully is on the cusp of doing so. So hopefully that provides some information for people who are facing a non-compete or thinking about it. If you have more questions about it, feel free to reach out to us or another Connecticut employment lawyer who can help you think about your situation.
This is great advice. Thank you so much. And remember that this is Connecticut law. So whether you're in New Haven, Hartford, Litchfield, Stamford, it doesn't matter. It's all the same that applies to you. Thanks so much for watching, and we'll see you next time.
Thank you.